part of appeals on the matter of DJ link cases in Wiltshire Police Department.
Yes, Mr. Chapman.
Very pleased, Your Lordships. As Your Lordships know, I'm making submission on Article 3.
Yes.
And there are 3 grounds, plus ground 4, in relation to additional facts we say the judge should have found. The certified leave given by Lord Justice Davies put the matter this way, that the judge found that there was no violation of Article 3 because there were 2 separate investigations, and it was only the second investigation, not the one conducted by D.S. Ellaby, which was an Article 3 investigation. That conclusion arguably was wrong. This is what the trial judge identified as being at the heart of the dispute also. And with respect, we agree. So perhaps the issue for your lordships is this, less pithily, whether the duty under Article 3 was animated from when the police were alerted of indecent images on the laptop on the 21st of December 2012, the D.S. Ellaby investigation, or only, as the judge found, when D.C. Sweeney took over the investigation in April 15, at the time of MP's arrest. In these circumstances, where, as the judge said of D.S. Ellaby, he effectively did nothing for 2.5 years, such that by the time MP was arrested on the 10th of April 2015, he had committed very serious sexual offences on these 5 children, aged between 4 and 10, 2 of whom had autism. That's HD and PD. And in that time, MP had been able to subvert the disclosure and barring service designed to bar unsuitable persons like MP to represent that he was suitable to work for children on 2 occasions, being the 10th of February 14 and the 20th of January 2015. None of this would have happened had D.S. Ellaby identified and recorded MP as the probable downloader of the indecent images. That, we say, was the work of a few hours, and on the judge's own findings, certainly it should have been done by January or February 2013. Your lordships will have noted that he was aware at the time of relevant dates, shall I say, on the files, the name of a top folder in which those images were contained with MP's name.
Sorry, can you just spell that out? I haven't quite followed that.
Yes, Lord, certainly. In the judgment, certain findings were made in relation to the photographs and the visit on the 21st of December. So paragraph 8 of the judgment, this is page 80 of the core bundle.
Yep.
The judge quotes a storm log which refers to 10 photographs which showed 6-year-old to 7-year-old boys naked in different poses.
Yes.
Dad was the one, this was the father who was a convicted sex offender.
Yes.
Given the laptop some time ago, and indeed if you look on the adjacent page at 81, he's recorded that was about a year ago. That's at paragraph 10. Further details are given. The boys in the pictures are around 6 to 7 years old, as he's already said. Most are either naked or without trousers, and some have been edited. And then he notes the people who were at the address, and there were 7 people at that household, being the mother, her new partner, MP, his 2 sisters, and 2 of their boyfriends.
Yeah. Now, I thought you made some reference to a title of a folder.
Ah, yes. The title of the folder was in fact identified when the computer was analysed.
Well, that wasn't until after 14, wasn't it?
Yes, well, what we say is that it was readily available and he should have seen the obvious. That references at paragraph 15.
Well, what about paragraph 10? The second paragraph. This is talking much nearer the time.
Oh, it is, yes, indeed. The
file says it was created on the 9th of December.
Yes, if you want the full chronology, my lord, at 10:30 the complaint came in. It wasn't Ellaby who took the complaint.
Yeah.
Ellaby then went at 8 p.m. with another officer to the family home, and by 11:30 he had made this entry.
The occurrence log.
The occurrence log, yes, and the reference for that is pleading the defence, in fact, paragraph 17.
Thank you.
And so there is, as you rightly say, a file he did look at with the date, which was the 9th of December. If he had looked at any other dates, he would have discovered, because it was identified by the tech unit, that there was an image, in fact the worst image, the category B image, created at 1:32 on the 21st of December, so in the early hours of the very day he visited. That's at paragraph 15.
Yeah, thank you.
Does that answer your lordship?
Yes, thank you.
My lord, I was saying that given the findings of the judge at paragraph 63, to which my learned leader took you yesterday, those primary findings of fact were entirely, if I may say, in our favour. And the question for your lordships is, what do we make of this in terms of Article 3? The judge concluded at paragraph 119 of his judgment that in these circumstances the law provides no remedy either at common law or under the Human Rights Act. Was the judge wrong in his analysis to allow such a conclusion? His approach to Article 3 is set out in the judgment at paragraphs 84 and following, and concluding with his discussion at 117 to 122. And if I could take your lordships to that part of the judgment, it's core bundle 113. And there are parts of this, my lords, which we readily accept, and there are parts that we do not. But the first 3 paragraphs there are, we submit, uncontroversial.
Sorry, first 3 paragraphs where?
Starting at paragraph 84 under the title, the claim under Article 3.
Yes. Okay.
Likewise, paragraph 87. and we accept that one of the leading cases for your Lordship's consideration today is indeed D and Commissioner of Police for the Metropolitan Police, volume 2000, reported in 2019, appeal cases 196, and your Lordships be aware there's also a Court of Appeal, the Court of Appeal decision in that case, also in the bundle, but in a supplementary bundle. I will take you to that in due course. The relevance of that case, perhaps, is that it involved it was a serial victim case. In that case, it arose out of the notorious black cab rapist, so-called, who picked up women in his black cab, drugged them, and sexually assaulted them. And a claim was brought under Article 3 in relation to two victims, one early victim and one late victim. And Mr. Justice Green, who gave the judgment at first instance, which was upheld in the Court of Appeal and in the Supreme Court, concluded there had been an investigative failure, but for our purposes, importantly, that the second victim was entitled to rely upon the failures in the first investigation. But more about that anon. Over the page, my lords, again, there's no real complaint about how he has set out the law. Paragraphs 88 and 89. And the way we put our case. Paragraph 90, he sets out the defendant's submissions, where they say that the DSD case should be distinguished. Their essential point was that the indecent images did not fall within the scope of Article 3, whereas the rape victim in DSD was obviously within the scope. Paragraph 91, the judge set out the parties' agreed list of issues for him to determine. Which he then went on to answer at various parts in the judgment. Beginning with whether the claimants were victims for the purposes of the Human Rights Act. Paragraph 2, one which is important, we submit. We ask the question for determination to be, is the threshold for seriousness under Article 3 determined in relation to A, the ultimate abuse suffered by the claimants, which is uncontentious that the ultimate abuse was indeed past the threshold, or B, in relation to the possession of child pornography on the computer seized in 2012, and the defendant's submissions which were accepted by the judge was that that didn't meet the threshold, or in relation to the children depicted in those images, which is a different point. Perhaps.
You've used the language of two separate investigations. That's not critical, is it? Because I mean, you could describe what happened as a change of gear when people became aware of the more serious sexual offences.
Yes, my lord. And when
I'm just wondering whether it's critical to either side's argument that it's two investigations. It seems to me it shouldn't be.
Well, we would say it is one investigation, and that is what we need to focus upon. It's artificial for the police to rely upon their own failures to deny that there was one investigation, because if MP had been registered as a nominal, there would have been one seamless investigation in that sense.
But what I'm just trying to be clear, it's not determinative of the outcome, whether it's one or two, because you would say, whether you call it one or two, there comes, well, your starting point would be it's Article 3 from the outset. But then you've got your secondary case, which is, even if that's not right, it somewhere relates back when it becomes more serious.
Yes, my lord.
And I think you've answered it, but it doesn't matter whether you describe them as that all as one investigation or two investigations or two sub-investigations or whatever.
Yes, we'll come to the way Lord Mance phrased it and how he connects one victim to another, if you like.
Yeah.
But yes, in the DSD case, for example, there would have been, I suppose, at one stage, two investigations, and then they're linked together. It's rather artificial to make this distinction. My lord, I think we reached paragraph 3 of the issues. If C, in relation to the children depicted in the image, can the claimants rely on those children's Article 3 rights to demand an Article 3 compliant investigation from the time the laptop was seized? So the idea there was that if the images of the children were sufficiently serious, can, in the words of the judge, the claimants in this case piggyback upon what he described as their rights. We object to that characterisation, but that was how he analysed it. 4 is said to be the critical issue. Should the court be concerned with failures in the overall investigation into MP, starting with Ellaby on the 21st of December and ending with Sweeney's takeover on the 19th of August 15? Perhaps it doesn't matter too much, but we query why that date. By that stage, that was 4 months after MP had been arrested. And in fact, DC Sweeney was involved on the day he was arrested, and that's in the chronology. Paragraph 5, is it necessary to establish a breach of Article 3 that the OB and HDPD children were capable of being identified at the time A, the computer was seized in 2012, or B, the time the computer was or should have been examined and reported upon? But also I think this was a decision that, an issue that the judge in fact resolved in our favour by reference to Sargentson, which we may come to. 6 is a factual matter. What were the failures of the overall investigation? 7, were the failures to comply with the implied obligations unduly burdensome on the police? And this is essentially the police's chief concern, that if it were right that indecent images triggered an Article 3 obligation to investigate, they would have their hands full. What we say is the question of whether this meets the threshold demands of a binary answer. Either this is Article 3 territory or it is not. If it is Article 3 territory, the police are under a duty to do something. It may not be very much, depending on the sliding scale, in the words of Lord Justice Laws. obligations. But in the context of a case where the judge has correctly characterised this as doing nothing for 2.5 years, we say there was certainly a failure, and that the correct characterisation is one of egregious and significant failure. All that had to be done was to identify MP as the primary suspect on the police computer, and he would not have been able to represent that he had an enhanced, clean DBS certificate, which he used to inveigle himself as a childminder for OB, HD and PD. CJ, PJ would also have avoided abuse on the judge's findings because the family would have been made aware, social services would have been involved. And also, causation test for a Human Rights Act claim is a lower threshold than one in negligence. But it doesn't matter in this case because the primary findings of fact are so with us that we succeed on balance of probabilities in any event. So paragraphs 9 and 10 were resolved, we say, effectively in our favour. The judge then set out our submission in a nutshell on what he described as the heart of the dispute. And we said this: it is the claimant's case that the court should be concerned with the overall investigation into MP, and only that approach satisfies the state's overall positive obligation under Article 3 to investigate and prevent child abuse. To hold otherwise is to salami slice the state's obligations to a nullity. At the core of this case is the police's failure to obtain intelligence about MP timidly, share it with those who were capable of acting on it, protect the claimants from abuse. Otherwise, we put it rather colloquially perhaps, why bother with working together and enhanced DBS checks? And perhaps this goes to a point which I will come to later, which is the distinction between operational failures and systems failures are sometimes hard to divine. And arguably in this case, there are two sides of the same coin. Because for all the opprobrium that has been heaped on DS Ellaby, it's hard to believe that he could have achieved so little, if I can put it that way, on his own. He did have supervisors, and there were things, we say, that could have been done, and I will take your lordships to that in due course.
Sorry, is that a submission that we should infer that other people were involved?
He had supervisors, my lord.
Yes,
and the complaint against him was that he took steps to evade supervision.
yes.
But as we'll see from some of his supervisors, there were things wrong with the system that would have flagged that he was not progressing this case.
Should have flagged.
Should have flagged, yes. My lend-lease sent me some references, but I will come to those references in due course. The rival submission was put by the defendant. The subject of the investigation, which began in December 12, was the provenance of the indecent images. The subject of the investigation, which began in April 2015, was the abuse of the claimant's HDPD and later OB and CJPJ, following the first report of a contact offence. The latter engaged Article 3, the former did not. So they rely heavily on contact offences as being the trigger for an Article 3 investigation. And one of the questions for your Lordship perhaps is this question of risk. Because to what extent does the risk of future offending form a factor to be taken into account when considering whether a particular misconduct falls within the threshold? And there is not good authority on this. Both sides have had to have recourse to judgments in the criminal courts to make some submissions about this. And those cases are the Crown and Tyrrell, if I remember, and
yes.
Crown and Cheshire. The judge then proposed to address some of the issues immediately. So he addressed issue 6 straight away. What were the failures in the overall investigation? And this relates back to paragraph 63, which we saw yesterday. And he says, I've addressed that at paragraph 63. In particular, I accept that there was a failure by DSLB to record on niche, and this we say is absolutely the key failure really, on niche that MP was a suspect for downloading the images. I do not accept there was a failure by the high-tech crime unit to examine and report on the seized computer by no later than 1 year after it was seized. I do not consider there is sufficient evidence upon which I could conclude either that the triage process was erroneous. And to the extent we complained about that at trial, I accept that that's not a good point anymore. Partly because the findings of fact here are so in our favour that the report from the high-tech crime unit is frankly a red herring. It didn't add anything of significance to the knowledge he required to add MP as a nominal to the computer system.
Sorry, I just need you to spell that out in a bit more detail, please. What is it you are not challenging any longer in paragraph 93?
Paragraph 93, the judge is dealing with our submission at trial, which was that the delay, as we said it was, by the high-tech crime unit to submit their forensic analysis was an example of a systems failure.
Yeah.
We say that's not required anymore for our purposes because DS Ellaby knew everything he needed to know on the 21st of December 2012 in order to make MP a nominal on the computer system.
Really?
I accept that. Well, I know my Lord Holroyde made an observation yesterday in relation to paragraph 63, and it may be that we should revisit that so that I can make good the point I've just made. I hope.
Well, I do just want to pin this down. In the middle of a third of the way through paragraph 93, the judge says, I do not consider that there is sufficient evidence upon which I could conclude either that the triage process was erroneous, it appearing that the images were not particularly serious, nor that once the computer was called up by PC Garner, the delay to April 2014 was culpable. Now, do you accept that that's a finding he was entitled to make, or don't you?
I do, yes.
You do?
The whole of that sentence.
The whole of it?
Well,
because your leader yesterday told us you were going to demonstrate conclusively that at least part of it was untenable.
Well, my Lord, I don't recall exactly what my leader said, but I thought he was saying that the entire period was egregious and...
No, he said that it was impossible to regard the images as not particularly serious. Predicted you would demonstrate as much.
It's that bit, my Lord. It appearing that I could conclude that... well, this is to do with the triage process. So what happens is that the officer who seizes the computer, Ellaby in this case, makes an initial assessment of what the images were and how bad they were, and submits to the high-tech crime unit, and that will govern how quickly it's picked out of the basket, if I can put it that way.
And what was his assessment? Where do we find his assessment?
Yes, well, lower matrix is the phrase he uses. That's at paragraph 8 of the judgment.
What does that mean?
I'm sorry, paragraph 10, the current log, last paragraph. As for the pictures themselves, I checked them briefly to check they were indecent. They appear to be lower end matrix.
Well, that's a permissible finding, isn't it?
Yes.
Yeah.
Yes.
So it follows through to not particularly serious, which again is a
Well, not particularly serious for the purposes of the resources that the high-tech crime unit have.
No, it's more than that, isn't it? It's not particularly serious within the scale of offences of this kind.
Yes, I would accept that. I mean, one image was category B. And
Yes.
The categories are set out.
Yes, but we're dealing, Mr. Chapman, with a type of offending where very commonly the police find hundreds or thousands of images in category A, still and moving.
Yes.
Here we have a total number of images in single figures, all but one of which are category C.
Yes. Well, my lord, I know that in the hardened world of the criminal courts, that is the reality.
Yeah.
But that does not mean, this does not meet Article 3. And when we come to Lord Hughes' judgment, we'll see that I accept as something of a lament, accepts that the threshold is quite low and is probably in the range of actual bodily harm.
Well, we'll come to that.
Yes, I mean, I'm not trying to suggest that this is top-level indecent images.
No.
Because they're clearly not. So, my lord, I lost my place. Forgive me. We were.
Sorry, my fault for interrupting.
No, not at all. We were looking at. Oh, this paragraph, yes, and whether we were going to persist with our complaint about the delay, and we don't, in relation to the high-tech crime. We say that's a red herring because it didn't tell him anything more than he already knew for the purposes of registering MP as a nominal. Except it's different in terms of prosecution because, of course, they would need to know forensically what the categories were, how many images there were, and prove to the criminal standard that he was the downloader. The judge then makes his finding that the local authority designated officer in social services should have been informed and that intelligence should have been provided on the enhanced DBS checks that I referred to earlier and his prospective employers, including the Scout Association. However, he does not accept that there was an overall investigation, and we've touched upon that. There were two separate investigations which eventually amalgamated in about July 15, so that's another date we don't quite follow why that differs from the one he gave before, which was August 15. Whether the initial investigation by DS Ellaby is to be treated as part of the Article 3 investigation is considered paragraph 21d below. And it may be that we turn to that paragraph now if it helps. Well, I would if there was a 121d. In fact, I think it's numbered, in fact, so that's probably 1, 2, 3, 4. Yes, it's 4, in fact.
These things are sent to try you, Mr. Chapman.
like judges.
Where he says there, should the court be concerned with failures in the overall investigation into MP, starting with Ellaby on the 21st of December and ending with Sweeney takeover, so we're back to the 19th of August now, or in two separate investigations, Ellaby's and Sweeney's. As I stated earlier, it is this question which is the heart of the dispute in this case. In my judgment, as submitted by Mr. Holcroft, the court is only concerned in the investigation of D.C. Sweeney, as this was the only Article 3 investigation. D.S. Ellaby's investigation was never an Article 3 investigation, and it was not and could not be transformed into one by MP's subsequent sexual abuse of these children, nor by the amalgamation of the two inquiries in July 15. The decision that the Article 3 duty was only animated in April 15 also carries a rejection of Mr. Bowen's alternative argument in relation to HDPD, paragraph 108. That argument was that when OB made his complaint on the 27th of February, that was a trigger for an Article 3 in the alternative investigation. And the police were not entitled to rely on their previous failings to say, well, we didn't know that he was the man we were after, and in fact they should have arrested him, and had they done so, some, I have to accept, relatively small period of abuse would have been avoided. But that's very much a secondary topic, perhaps. So we were at 98. Where were we, in fact?
93.
93, thank you, my lord. 94 were the failures to comply with the implied obligations unduly burdensome on the police. He did not think that issue was well drafted, but it is my view that it cannot be regarded as unduly burdensome to require the police not to act negligently. The defendant's response that it would be unduly burdensome to require police forces to conduct Article 3 investigations which do not involve treatment contrary to Article 3 addresses a different question and is answered below. And so perhaps that is an acknowledgement that the real question in this case is, was Article 3 engaged? If it was, the police have to do something. If it's not, they don't.
Well, I must say, speaking for myself, I don't fully understand what the judge means when he says it's not unduly burdensome to require the police not to act negligently. I had understood the reference to the implied obligation of being unduly burdensome as a reference to the generality of the proposition that the minute there's any indecent image, an Article 3 investigation has to be launched in every case.
Yes.
However impractical that is, however many possible suspects there might be to be considered.
Well, indeed, I think this was...
I mean, it's never going to be unduly burdensome not to be negligent, because if it was unduly burdensome, you wouldn't be negligent in the first place.
That's right.
With respect to the judge, I don't really understand that. Anyway, it's a point you can take advantage of, and so on.
Well, I won't be so mercenary, my lord, but I suspect it's a reference back to paragraph 63, where he did describe, in fact, the police failings as negligent. I think I'm right. Yes, paragraph 63. However, in my judgment, the negligence of the defendant went significantly further than is found by the disciplinary panel. So maybe that was what he had in mind.
Right.
And on paragraph 95, he develops a theme of culpability by asking were such failures in the overall investigation egregious? And what he says is, I have no doubt that DS Ellaby's failure, once he had received the report of the high-tech crime unit, were egregious. And in fact, the report was sent to him in April 14, 23rd, I think. And this was effectively the opinion of the disciplinary panel, which would have dismissed him from Wiltshire Police with immediate effect, but for the generous approach of the families. Your Lordships may recall that the disciplinary panel investigated only the second period, and the defendant accepted the findings by admission of that panel for that period, but not anything earlier. However, in relation to the period prior to May 2014, in my judgment, the failures which I have identified, although culpable, were not such as to be described as egregious. And then he sets out what he says are the reasons why. DS Ellaby had not yet received the report from the HTCU. That's one. And his other duties caused him to prioritise those ahead of a further investigation into what may have appeared to him to be relatively minor indecent images. Furthermore, he appears to have assumed that BP, the father, was most likely to be responsible, and he was already being monitored as a sex offender because of his offences against DJ, that was MP's sister, who had left home by that stage and was the mother of CJ PJ, who, because she was working, let her mother do a lot of childcare. My Lord, so we don't accept that at all. We say it's illogical to make the distinction in that way, and went against the weight of the factual findings he'd made.
Why is it illogical? Would you accept that the applicability of the word egregious is likely to be, or may be, affected by the seriousness of the information that is available to the police? So that, for example, if Mr. Ellaby had been given War Boys information and had behaved in the same way, by War Boys information I mean clear evidence of really serious sin, and had behaved in exactly the same way, the seriousness of the information may have tipped an assessment over from not egregious to egregious. I know you don't accept it's not egregious anyway, but
yes,
you see what I'm after.
I accept the generality of the point,
Yeah.
but what the police can't do is rely on their turning a blind eye or failing to do even the most basic things. For example, to establish that CJ and PJ were children to whom he had ready access. He didn't carry out any assessment at all.
But this is an argument in a circle, with respect, Mr. Chapman. Egregious, as my lord suggests, surely indicates something of a markedly higher level of culpability than some other failures. And you've accepted that the judge was entitled to find that within the scale of offending of this kind, the images were not, were at the lower end of the scale. There was an obvious adult suspect who was already being monitored in other respects. Why was it illogical for the judge to say, well, that's one level of seriousness, but everything gets much more serious when the report comes in?
Because the report doesn't add anything to that which he knew or should have known It was plain on the face of what he'd written at 11:30 on the 21st of December that MP was the prime culprit.
And so you'll have to help me with that. Why was a 16-year-old boy the prime suspect, rather than the father, who was already accused of sexual offending against children?
That was just an impression which should have been dispelled immediately, because forensically, if you look at the date which he had, he knew the date of the files. He knew the name on the folder.
Did he know the name on the folder? Well, he didn't.
Well, he didn't.
The only name on the folder is just a series of characters, letters and numbers.
No, my lord. I don't want to say.
You're referring to the information in paragraph 10.
Yes. And we say that was plain.
He knew that it was created, or said it, but the file said it was created at 7:31 on the 9th of December.
Yes. And the second line down, these images were contained within a folder named, and I won't say the name.
Sorry, second line down where? I'm so sorry, I'm just
No,
missing.
my lord, it's page 83, paragraph 15.
Paragraph 50.
The categories are set out, and then there were 8 indecent images on the laptop, one falling into category B,
Yeah.
7 category C. These images were contained within a folder.
Yeah.
And we say it was culpable not to have clocked that on the 21st of December.
The name on the folder.
Yes. It's a top-level folder.
Was that actually? Sorry, I'm not sure if I entirely understood this, but it only mean that was being suggested that was obvious, or should have been obvious from the 21st of December.
Yes.
Was that part of what was being put to the judge?
Yes. I'm fairly confident we did make that point.
Well, what's the judge's finding on it? I mean, you seem, if I may say so, you seem to be saying that rather than sending it to the specialists, the officer who sees the computer should do his own clicking around among the contents of the computer. That may be right, may be wrong, but I would have thought it would be the subject of evidence and argument and a finding by the judge.
Well, my lord, we'll turn to the guidance, the police guidance in due course. And I hope I'm right in saying this, that there is often delays getting forensic analysis.
Yes, there are.
But that mustn't stop obvious investigations.
In this case, therefore, it was a complete waste of time. But I mean, he didn't need really to send it to the forensic unit because he had everything at his fingertips.
He did to make the prosecution. He didn't need to make the man the nominal.
I'm sorry to keep worrying away at this, but you keep talking about making NP a nominal.
Yes, I shouldn't use that phrase.
Well, no, just tell us what you mean by it.
It means making an entry on, they call it the niche system, which
Yes.
is a computer database system, that this man is a prime suspect.
Right, but how do you say that should have been done on the 21st of December? There was a household full of people who had access to the computer. There was an obvious adult suspect. Everyone denied it. What's the basis for saying Sergeant Ellaby should immediately have focused upon a 16-year-old boy?
My lord, because that was the only inference you could make based on the date of the files and the name on the folder.
The judge doesn't appear to have dealt with this issue, therefore, that was fundamental to your case.
No.
Really.
Is
Is that what you're saying?
Well, it certainly his criticism of Ellaby does not go that far. I accept that. We say it should do, because there was no logical reason to divide the. Either he was not egregious for the entire period, or he was for the entire period. And we will come to further aspects of egregiousness, because one of the troubling features of this case is that Ellaby knew he was not qualified to take on the case. but did so anyway, if I can put it this way, to improve his CV.
Well, that's been used rather pejoratively. It was actually, I think the words used was to, as it were,
Improve his skill set, I think it was the...
Your strongest point on knowledge, as it seems to me at the moment, is in paragraph 10 of the judgment. Penultimate paragraph of the cited thing. He says, I intend to submit this for examination because should the creation of that folder predate the time when CP was handed the laptop, about a year ago, and your criticism is that with the information he has a file, a relevant file, which says that it was opened 12 days before, and therefore your submission, as I understand it, is therefore he had sufficient to put 2 and 2 together and see that the prime suspect is or may be someone who's in the house, not CP. That's your case.
Your Lordship has it. He should have been able to rule out.
And that's the failure to be inquisitive and put 2 and 2 together contributes, you say, to what you say is an egregious failure.
Yes, Lord.
Have I left anything out?
My Lord, well, I was going to take your Lordships through more detail, because there is more detail in the supplementary rebuttal, but I don't wish to do that at this stage, for fear of jumping around the judgment.
Take your own course, Mr. Chairman. Thank you.
My Lord, 96 we have no complaint about, because it's the causation issue. 97, did those failures cause the claimants to lose a real prospect of altering the outcome or mitigating the harm? I've already found that DS Ellaby's failures caused the claimants to suffer abuse when otherwise they would not have done. However, the alignment of that question with engagement of the state's responsibility amalgamates 2 questions and begs the question whether the investigation by DS Ellaby engaged the state's Article 3 responsibilities at all, which remains to be decided. So he's reserving his position there. He then rehearses the submissions on our behalf, and he said that our submissions are relatively simple and involves the following submissions. Article 3 is in issue and engaged because the investigative duty is triggered by the subjection of all 5 claimants to inhuman treatment at the hands of MP. And this is what the defendants complain about and the judge complained about as a type of retro, that it wasn't fair to fix the police with matters about which they did not know, in essence. And then we come to questions of risk and whether risk is a relevant part of Article 3 considerations, risk of further offending.
I'm really sorry to keep interrupting you.
No, my Lord.
But 98.1, is that an accurate statement of your submission?
Today, my Lord. Or as we made it then.
As you made it then.
It's a somewhat crudified version, my Lord, if I might put it that way. I suspect at the heart of this was our submission that this had to be looked at as both a systems and a operational failure overall. I accept, for this purposes, that it would not be right simply to say these people have suffered Article 3 harm, therefore what happened when the images were found, there's an automatic leak. I accept that.
Well, it seems to me, with respect both to you and the judge, that the way you're putting the case is completely different from 98.1.
Yes.
98.1 must mean that Article 3 isn't engaged until at least one of the claimants actually suffers inhuman treatment, and that's months later. And if it's not engaged till then, it can't retrospectively engage way back to December 2012. But as I understand your submission today, you're saying to us and saying you said to the judge, that's not the approach at all. The whole thing is an egregious failure from day one, with Article 3 being engaged from day one by the mere discovery of a number of indecent images.
Well, we would say it wasn't just the mere discovery of the images. And when we come to look at the threshold question, it's more nuanced than that. And the requirement is to take into account all the circumstances of the case.
But I think you are accepting, just to pick up what my lord said, that the fact of the 5 claimants being abused subsequently does not necessarily mean that Article 3 is engaged from the outset.
I accept that.
That's accepted. Thank you. So you have to satisfy the court that there is a moment, you would say when Ellerby first goes, that there is a moment when things become so serious that Article 3 is engaged.
Yes.
Either as on the basis of actual allegations having been made, or, as you would say, on the basis of inferences about risk.
Yes. And I'll just flag now, one of perhaps interesting questions is it, should the police be fixed with the risk that might be said to arise when he actually applies for a DBS certificate? Because somebody who has a sexual interest in children, who then makes an application, you might say the police should have known about that. It's an indication that that person is moving in the wrong direction. But as we put it, and I have to accept this, as we put it in our skeleton argument, we say the next date is the complaint by OB.
The DBS is surely, that whole system is based on what the records. It doesn't trigger, as it were, an investigation in itself into a person, does it?
No.
It's based on what is already there, and you say it should have been there because from the very beginning, because she should have been on leash, etc.
Yes. Yeah. Well, can I trouble somebody for some water?
Thank you, Mr. Warner.
Thank you, Mr. Warner.
But the DBS is not a subset of the police, is it? It's a non-departmental public body of the Home Office.
Yes, there was a note prepared, and the judge has accurately set it out. It's paragraph
60, I'm looking at.
Paragraph 60, yes. That's right, my lord. It's over the page, however, 61, the enhanced DBS check, and this is where the police do seem to be involved. The certificate this is the one he actually applied for, the DBS check, that's number 3. The certificate may also contain non-conviction information supplied by the relevant police forces, if it is deemed relevant and ought to be contained in.
Okay, but I thought you were suggesting that the police should have known when he made the DBS application, and that should have.
Well, my lord, I think your lordship's right.
The
yes,
risk.
I accept that.
Yep.
It's a bad point.
Thank you.
Yes. So, paragraph 2, pursuant to the Convention, the State has an obligation to ensure that reasonable and proportionate steps are taken to prevent such inhuman treatment. There have been well-established negative and positive obligations to avoid violations. Reasonable and proportionate steps could have been taken which have prevented the claimant's sexual abuse by NP. Yes. The duty imposed on the State must not be unduly burdensome. And what the claimants are suggesting should have happened is not unduly burdensome, but basically seems in accordance with established systems. And the court's approach should be to give practical effect to the claimant's Article 3 rights. And to deny the claimant's remedy would be to empty Article 3 of its potency and cause the protection afforded by Article 3 to be neither practical nor effective. I suppose that's echoing our salami slicing point on the previous page. Mr. Bowen, QC, referred then to the defendant's case that no investigative duty was triggered before 9th of April 15, so that's the day of MP's arrest, when the investigation was opened into MP's alleged sexual assaults. He suggested that if that is right, then despite there being obvious preventability, there was complete absence of protection under the Convention. And if that is correct, it would defeat the entire purpose of protection under the Convention and the HRA and the safeguarding scheme. He submitted that if that is indeed the law, then the law needs to change. The policy was concisely expressed by the ECHR in Z and others. 34 EHRR3 at paragraph 73, a well-known passage which is set out there. For the defendant, the operative words are the final ones, ill treatment of which the authorities had or ought to have had knowledge. What we say is that the images of those children was Article 3 harm. It's very hard to see how those images could not be understood as anything other than inhuman and degrading. Inhuman and degrading, my lord, which is the word of the... if I needed to emphasise, although I accept the categories, of course, but the judge was not asked to look at the pictures, of course, and nobody invited him to do so for obvious and understandable reasons. But a nature, the sort of character of them is set out at paragraph 9. It was enough to make Ellaby jolt back in his seat. And when I looked at the screen, I could just see, and I'm not going to read that because it is degrading.
But this is the Article 3 rights of the children depicted in the images.
Yes, and this is one of the...
How do we jump from there to the Article 3 rights of all persons who may come under the malign influence of whoever it may have been who downloaded the photos?
Well, this is the test suggested by Lord Mance, in fact, about that a victim is somebody who can. I need to be very careful about how I say this.
Which case are you wanting us to look at?
My lord, may I just bring it up and then I will take you directly there rather than...
Yes,
me.
please.
My lord, yes, it's in DSD in the Supreme Court, if I may put it that way for shorthand, which is tab 6 of the core authorities, and Lord Mance's judgment begins at 263 of that bundle.
Thank you very much.
And it's the final sentence. If there is such a duty, meaning the operational duty...
I'm so sorry, which paragraph?
I'm sorry, 141, my lord.
Thank you. Thank you.
And the part I rely upon is if there is such a duty, that is the operational duty to investigate serious offences, then I do not see that it can or should be confined to the victim of the offence in question. And part of its purpose must be not only to punish, but also to deter and to prevent the occurrence of further such offences. And if a third person suffers foreseeably as a result of a failure properly to investigate, that third person appears to me, potentially at least, to be a victim. Now, that, as far as I'm aware, has not been expatiated elsewhere. But and I can see your lordships are thinking, well, that's a very wide proposition.
But does it matter? Because if if you're right, and these 7 or 8 photographs demonstrate inhuman or degrading treatment for the purposes of the article, which is something you'll have to satisfy us with, then Ellaby should have been pursuing an Article 3, and whether or not the claimants were in contemplation, it would have had the desired effect if a competent Article 3 investigation had been carried out, because niche, he never gets employment and so on.
Yes.
That's
That's the way my argument is going, my lord, yes.
yes.
We say there was an Article 3 duty. If there was, then it is foreseeable that if you don't do that properly, and it's egregious and significant, that the claimants will suffer as a result.
Yes, but what that entails, what you're not doing properly in that proposition, is you're not investigating the evident abuse of the Article 3 rights, if that be the view, of the children depicted. You've no idea who they are, what country they're in, how they could be identified, whether the photographs were taken last Tuesday or 15 years ago. And I think we have to be careful not just to talk about an Article 3 duty in a vacuum. What do you say the police should do to investigate the Article 3 rights of a child depicted in an image which has been downloaded from the internet?
Well, it will depend on the circumstances of the case. But here...
Why? Because your proposition is that this sort of imagery, we can debate in due course whether these particular images did or didn't pass an Article 3 threshold, but suppose for the moment they do. Your proposition is that when any image on its face engages the Article 3 rights of the child depicted, an Article 3 investigation must begin. And I just want to know, what are the police supposed to do?
Well, my lord, I'll repeat that it will depend on the circumstances. It's not a trigger for a massive duty. The word used by, I think it was Lord Justice Laws, is animated. That animation may be very little. And we say, in this case, there wasn't a great deal that had to be done. But within a matter of hours, MP should have been identified as the prime suspect and recorded as such.
I think that's special pleading. Yeah, and I think it's special pleading because it's inherent in Article 3 that you've reached a significant level of seriousness. For example, here, you've got 8 photographs. We have no information as to whether they are or maybe the same child. At the moment, rather with my lord, I don't think you can duck my lord's question simply by saying, well, it would have been simple in this case, because that's not his question.
Well, I think that perhaps the danger is putting a common law negligence type hat on when it comes to considering the Article 3 duty. What Lord Mance is saying there is it's all about the purpose, the overall and overarching purpose of Article 3, which is to not only punish, but also to deter and prevent. If your lordships were to say, well, there's nothing that's to be done, there are so many of these indecent images, really the police shouldn't be expected to do anything, that becomes a self-fulfilling prophecy. The offences will proliferate.
Well, that's an argument in terrorem, which
I'm sure I haven't put your lordships into...
No, no. But you see, I don't mean this in any way unkindly, but the fact of the matter surely is you're not interested in the slightest in the police investigating the rights of the child or children depicted. You're jumping straight from that to what should have been done about MP. And that's the stretch which at the moment I haven't followed.
My lords, the problem of child pornography.
Well, we tend not to call it that in the
I'm sorry,
jurisdiction because it
indecent.
devalues it.
Indeed, indecent images. Involves, in this case, consumption to gratify a sexual desire. But for every consumer, there is a producer. And so they go hand in hand. Because the producers of indecent images are hard to find, the law comes down very hard on the consumer.
All right. Well, let me not interrupt you further.
Well, I will try to make better that submission in due course. I can see it troubles you, Lordship. Well, where did we get to? I'm sorry. We were...
You, in the judge's judgment, you were last at paragraph 98.
99.
99.
Thank you very much. I was over the page. Dealing with Mr. Bowen's further submissions at paragraph 100, that even if the Article 3 obligations were not triggered until the contact allegations were raised in April 15, the police would then have looked at the overall span of the offending, as illustrated by the amalgamation of the two lines of inquiry, the Ellaby and Sweeney lines in July 15. He submits that it is then legally necessary to look at the whole span from December 12 and ask steps which should have been taken to avoid the abuse. So that's perhaps putting what was more crudely put at 98.1. Mr. Bowen then referred to D and Commissioner Police can be distinguished from the present case because there the investigation was an Article 3 investigation from the start, the initial complaint being one of rape. He submits that here Article 3 is engaged from the get-go because we have 5 children whose Article 3's rights have been violated. The failures predated the abuse, but he submits that does not prevent them from biting. This is a necessary consequence for the law to command the confidence of the public and to make sense. The control mechanisms are that the obligation must be practical and effective and not impose an overburdensome onus on the state. Breach of the operational requirement to investigate requires egregious error, and the treatment must be sufficiently severe to satisfy the threshold under Article 3. Referring to the judgment of Mr. Justice Green, as he then was at first instance, in that same case, where from paragraph 139 he analysed the authorities on the duty of the police to investigate torture and degrading and inhuman treatment committed by third parties where the police are not complicit in the perpetration of the treatment. Following his analysis of the authorities, Mr. Justice Green identified 13 main propositions to derive from those authorities, and Mr. Bowen relied in particular on 5th and 6th set out there. And I believe these come from the case of X and Bulgaria, which we'll come to. Fifthly, where a credible allegation of a grave or serious crime is made, the police must investigate in an efficient and reasonable manner, which is capable of leading to the identification and punishment of the perpetrators. The question of what is meant by capable raises some important issues, and I address these in more detail, the judge says. Sixthly, the duty is one of means, not results, and that may be an important consideration, that whether the perpetrator is in fact arrested, prosecuted successfully is not the point. The point is that an investigation, an adequate one, is carried out. The breach can occur in principle regardless of whether the investigation leads in fact to arrest, charge and conviction. In paragraph 103, Mr. Bowen submitted that there is further significant support for the claimant's case in D and Commissioner in the Court of Appeal, and then quotes a lengthy passage from the headnote, I think. Although convention guarantees were only enjoyed against the state, and ill treatment by a non-state agent did not of itself constitute a breach of Article 3, it was inherent in the convention's purpose that the state was to protect persons within its jurisdiction against such brutalities, whoever inflicted them. And as a result, Article 3 accorded safeguards which were broader than the bare prohibition of acts of torture or gross ill treatment by servants of the state, and extended to ill treatment by persons who were not state agents and had an overall strategic purpose to safeguard and protect in all the myriad situations where individuals might be exposed to ill treatment of the gravity which the article contemplated. That investigative processes could be regarded as ancillary to that purpose or adjectival to the substantive right where there was a credible allegation of ill treatment by state agents, but that where ill treatment was by non-state agents, there was no antithesis between what was substantive and what was adjectival. And in such a case, Article 3 generally required a proper investigation and criminal process where the investigation so led. That in applying a single principle with varying degrees of rigour according to the gravity of the case, there was a sliding scale from deliberate torture by state officials to the consequences of negligence by non-state agents, and that the margin of appreciation enjoyed by the state as to the means of compliance with Article 3 was wider at the bottom of the scale than at the top, so that at the lower end of the scale, the state's provision of a judicial system of civil remedies would often suffice. But serious violent crime by non-state agents was higher up the scale and required a proper criminal investigation, the first and second cases being in the latter category. So this was the sliding scales point of Lord Justice Laws I referred to earlier. And indeed, I'm sorry, the next paragraph starts. There is perhaps a sliding scale, etc. The energy required of the state to combat or redress these ills is no doubt variable, but the same protective principle is always at the root of it. The margin of appreciation enjoyed by the state as to the means of compliance with Article 3 widens at the bottom of the scale but narrows at the top. But what may, without belittling the victim, be called the lower end of the scale where injury happens through the negligence of non-state agents, the state's provision of a judicial system of civil remedies will often suffice. If individual states' legal traditions will govern the means of compliance in a particular case, serious violent crime by non-state agents is of a different order, higher up the scale. So at the same point, obviously in D and V, there was really no argument. Well, paragraph 104, referring to the expression used by Lord Kerr, it is suggested that it would require the clearest statement in consistent decisions of the European Court of Human Rights Grand Chamber to the effect that a deposit duty was owed by the state to individuals who suffered treatment contrary to Article 3 at the hands of another individual, before holding that the investigative duty of the state was animated. I think that was the argument there was that the police were saying that they weren't responsible for third-party harm. And Mr. Bowen submitted that in this case, Article 3 and its obligations is animated merely by virtue of the fact that the violation of the children could have been prevented.
Is that going back to little 1 on paragraph 98?
I think so. I think it's a crudification of the
It's how the case was being put then.
Yeah. Sorry, Miller.
How the case was being put then.
Yes.
Thank you.
What is not in the least uncertain, however, is that if the relevant circumstances are present, there is a duty on the part of states and authorities to investigate. Where non-state agents are responsible for the infliction of the harm, that cannot be characterised as other than an operational duty. The debate must focus, therefore, not on the existence of such a duty, but on the circumstances in which it is animated. And the use of the word animated, we say, is telling. In common law negligence, the court only has to determine what the standard is, whether it was breached, and then there is a waterfall event, if you like, of foreseeable loss and damage. Whereas under Article 3, the focus is less on the consequences for the claimants and their damage, and more about the duty on the state to have an adequate system to prevent serious Article 3 harm. Mr. Bowen referred to a text which perhaps I have here by Harris, O'Boyle and Warbrick, and relied upon the passage. The obligation contains both preventative and investigative elements and follows the example of the positive obligation of protection in Article 2. The preventative obligation requires the state to take appropriate steps to protect individuals against other private persons, so that most significantly there is a duty to protect children from physical and sexual abuse by parents and others, and to protect against domestic violence. So we say on the authorities that children, and vulnerable children in particular, the requirement is one of special care. That there is more animation, if I put it that way, required. And your Lordship to be aware that 2 of these children were autistic. Mr. Bowen then referred to some of the guidance that was available to the judge and about how the police should conduct an investigation like this, and what was the advice known at the time. In particular, we relied upon interviewing a suspect prior to the digital examination of seized storage media, provides an opportunity to establish specific information such as the ownership of the computer and who has access to it. So, my Lord, that may go some way to answering the query you raised earlier.
So, which passage are we looking at?
I'm so sorry, my Lord. It's 105, and it's the quote indented.
Yes, but you were then coming on to the guidance.
Yes, well, this is the page. This is the National Police Guidance, ACPO guidance. It's now the College of Policing, isn't it? But at the time, that was the organisation which provided that guidance, and there was relevant advice in relation to interviewing in connection with child abuse images.
Right.
Then Mr. Bowen made his Sargentson point. That's the case of Sargentson and Chief Constable of Homicide Police 2014, Queen's Bench Division 411. Lord Dyson, Master of the Rolls, made the point about the scope of identifiable victims in relation to an Osmond case. And the judge answered that in our favour at paragraph 121(5). I accept Mr. Bowen's submission in this regard by reference to, for example, Sargentson. But the premise, though, is that the earlier investigation has to have been an Article 3 investigation. That is why the defendant succeeded in that case, but the claimants here must fail. That is why D, succeeded. No Article 3 investigation was triggered by the inquiry into the images on the laptop computer.
Where are you?
I was looking at the answer to Mr. Bowen's submission at paragraph 106,
Yeah,
paragraph 121(5.
thank you.
So 107, Mr. Bowen outlined his system failures point. Mr. Bowen referred to the obligation of the state to have adequate systems to protect the Article 2 and 3 rights of its citizens. Obligation now well established in relation to NHS hospitals. For example, the well-known case of Rabone and Pennine NHS Trust 2012 2 Appeal Court 72. But equally applicable to the police. He submitted that there were systemic failings here in relation to the training of the relevant officers, and particular DSLB, in the supervision and management, in the allocation of resources, and in the making of risk assessments. Whilst acknowledging that the HTCU had a backlog, and this is a point which we don't pursue, he submitted this could not justify the investigative failure and the delay, because Article 3 is absolutely right, and lack of resources cannot excuse violation of the Article 3 rights. And I think His Lordship's argument at trial was that a year was reasonable for the high-tech crime unit to report. I think it was a bit longer than that. In relation to the case of HDPD, Mr. Bowen raised a specific issue, and this is the specific and rather secondary question in relation to an Osmond duty in respect of those claims.
So, just catching up, the final sentence of paragraph 107, that submission is now abandoned.
Yes, my Lord, we do not complain about the HTCU delay, because we say it's irrelevant in this case.
No, and we've had this before. I'm sorry. I do want to know whether the submission of principle is abandoned or not. The submission of principle has this consequence. Your argument is, the moment the police find an indecent image of a child, the Article 3 rights of that child must be investigated, and it will be no answer to a breach of Article 3 to say, well, we haven't possibly got the resources to investigate every such matter. Now, is that submission of principle abandoned or maintained?
I mean, Lord, it may be that there's a confusion. This is in relation to systems. This is a systems point. The argument here before His Lordship was there was an inadequate system in relation to the high-tech crime unit, and in particular the delay and backlog was unacceptable, and therefore the system failed. But I don't say that today that HTCU backlog is something we can pursue. We accept the judge's factual finding on that, which is that it was appropriately triaged, and the report came back, I think it was 15 months later, and that was reasonable.
Okay.
To some extent, if there is a systems failure in this case, we do not have to worry about unduly burdensome, because it's inherent if there is a systems failure, if the system is not adequate to meet the needs of prevention, that we succeed. It's built into the whole concept of an adequate system, but it's not unduly burdensome. The question is were there serious and egregious failures here as well. And I don't rely upon delays in relation to HTC.
Are you saying there is a systems failure here, though, taking out the forensic unit?
I'm sorry, Lord.
Are you saying there is a systems failure here, taking out of account the forensic unit?
Yes, my Lord, I outlined that earlier, which is that
That's still being maintained.
That's still being maintained. I just don't rely on that aspect. My Lord, at 109, Mr. Bowen made what's described as his general duty to society point to protect its citizens, relying on a case called, I cannot pronounce this, if I may call it Blizzak and Croatia, application number 74448, and that is in the bundle, where the judge describes this accurately as a resentful and mentally disturbed husband had gone on a shooting spree, so a very terrible case, grievously wounding his wife and killing his wife's lawyer in divorce proceedings before finally killing himself. The relatives of the lawyer brought a claim under Article 2, criticising the police for failing to take obvious steps to apprehend the husband before he killed the lawyer. The ECHR held the positive obligations may apply not only to situations concerning the requirement of personal protection of one or more individuals identifiable in advance as the potential target of a lethal act, but also in cases raising the obligation to afford general protection to society. Hence, it is submitted that the defendant owed and breached a duty under Article 3 to take reasonable steps to protect society in general, and young identified children in particular, by failing to take reasonable measures after MP was identified as responsible for downloading the images in the HTCU report.
But what about the final word?
Which was available as from 20th of May 2014.
So that seems to be a complaint about what was and wasn't done after May 2014.
Yes, my Lord, but at the time we did maintain that there had been delay in relation to the HTCU report, and there was delay after that.
It's not a delay point.
I must
It's failing to take, if you cut out the reference to the HTCU,
yes,
it's failing to take reasonable steps, etc., by failing to take reasonable measures, ... as from 20th May 2014. Not as from 21st December 2012.
yes, that puzzles me, my Lord.
That's a disarming submission.
If I may say, because our case, I thought, had been fairly put, and I think recorded elsewhere from the judge, that we were complaining from the very beginning, and indeed the judge did deal with it and rejected that finding, that there had been egregious harm before. So I'm not sure why that date is there.
All right.
And we then moved to the defendant's submissions, which ultimately found favour with the judge. And Mr. Holroyde accepted that there was a duty to conduct an investigation compliant with Article 3, but only once there was an allegation of treatment contrary to Article 3. The downloading of indecent images doesn't constitute treatment contrary to Article 3, but sexual abuse of children does. So he makes what I say is the stark distinction between non-contact and contact offences. And therefore he put the date for an Article 3 being investigation being animated as late as the date of arrest, basically. The investigation then carried out by DC Sweeney was, he submitted, fully compliant with the investigative and operational duties. So as I understand it, DC Sweeney was involved from the date of arrest.
We've read all this. We haven't got time to have the whole judgment read.
No. Do you want to make that?
My Lord, I think I overheard and I understand.
I mean,
Yes.
if there are things that you need to highlight,
No, Miles,
but just reading, you can assume that we've read the skeletons and
Yes,
followed up references, and we have read the judgments.
yes. Well, my Lord, perhaps we should just move to immediately to the discussion, because I think that the rival submissions are well understood. Paragraph 117. And essentially it's this part where he finds against us. the words investigations into criminal conduct which fell foul of Article 3 are important and significant. It is the fact that the conduct fell foul of Article 3 that informs the inquiry into the standard investigation. And in my judgment, the whole rationale falls like a house of cards if the Article 3 duty is extended retrospectively to an investigation into criminal conduct which did not fall foul of Article 3. So that was the way he analysed it. And he accepted Mr. Holcroft's submissions on that. And as he says, pretty much everything else followed. Well, I think I've already taken you to some of the principal conclusions that arose from the rival submissions already. So with that, I think perhaps I can leave the judgment.
Very good, thank you.
Sorry.
Forgive me. Forgive me.
It's quite all right. Do you want us to rise for a couple of minutes so you can have time to...
No, that's fine.
My Lords, can I give you my headline submissions there?
Please.
Our answer in a nutshell to the judge's findings against us was that his analysis was faulty, that there was, this is primary submission 1, there was a single investigation because either there was Article 3 harm in 2012 upon which these claimants can rely, namely the harm to the children in the pictures, and or this should have been regarded as a systems failure on the basis of my point that it wasn't just Ellaby's fault, that he had in some sense been let down by the system. 2, that the overall investigation was egregious and faulty, and the judge's finding to the contrary can't stand.
You've got a bit of competition from outside. Could you...
I'm too low now. You can't hear me.
The overall investigation was...
egregious and significant.
I thought that's probably what you were about to say.
Thank you, my Lord. Yes, you heard me correctly then.
I didn't.
The judge's finding to the contrary cannot stand. 3, if the Article 3 duty was animated in 2012, and we're right about that, then it was not lifeless. What was required might not have been very much, but it required at least what we say was the work of a few hours to identify MP as the prime suspect for these images, but viewing these images, and that being recorded on the computer system. And in relation to the discrete point that HD and PD might have been better protected, we say that the judge's own findings about this were that from May 14, Ellaby's failings were egregious and significant. And the complaint by Obi, which was on the 27th of February 15, in relation to him being forced to watch indecent images, must have meant that either Article 3 harm had taken place or there was a real and immediate risk of it. But if we're right on our primary submissions, then all these claimants are entitled to a finding that they, because of the breach of their Article 3 rights, they would have avoided all the abuse by MP. My Lord, there was, I'm conscious of the time. My Lord, I was conscious yesterday you made an observation to my learned leader about paragraph 63, and it may be that we have covered that. But in case we haven't, I just wanted to check that you were satisfied with the point I was making in relation to that. And this is at page 101, where the judge said that found the defendant's failings went significantly further than was found by the disciplinary panel. And as I understood, my Lord Holroyde, yesterday, that I may have got it wrong, that your impression was that the judge had not found that anything was required until the laptop had been obtained. Was that wrong, my Lord?
Well, paragraph 63 begins by referring to the findings of the disciplinary panel, which, as I understand it, is later, significantly later than 2012. The particular subparagraph I questioned was subparagraph 4, which I'm afraid I simply don't understand.
Yes, maybe, my Lord, these paragraphs have to be carefully read in chronological order, as it were.
Yes, well, I've endeavoured to do that.
Yes.
Starting higher up the page and ending lower down the page.
Well, that's right, my Lord. So, paragraph 1.
But you see, little 2, he should have ascertained, 1, he should have ascertained how long it was going to take, answer probably at least 12 months.
Yes.
2, should have thought about what to do in the meantime.
Yes.
3, should have interviewed everyone who had access.
I wouldn't miss out the words first priority.
Yes, okay. And then 4, it was what puzzled me was the suggestion that because MP was a child, an experienced officer could be expected to elicit appropriate admissions. It seems to overlook legal representation and appropriate adults.
I'll have to check, my Lord, but I think
later he did actually.
He did,
Then was when the actual contact was. I
Yes.
presume that's where that.
Well, that's when the laptop.
Yes, and the contact.
I mean, every member of the family had been asked by Mum, and they'd all said, "Not me."
Yes.
So the judgment seems to assume that if D.S. Ellaby had said, "Well, I'm an adult and you're a child, was it you?" MP would have said yes.
Well, yes, I can see
that's
that.
an unfair characterisation, obviously.
Well, he's paying tribute to D.S. Ellaby's experience, he says, as a senior, well, he was a sergeant, wasn't he? I guess children tend to say, are more revealing perhaps to figures of authority than to their own parents sometimes.
Not sure those who sit in the youth court would necessarily agree. But,
Oh, my Lord, I don't understand the challenge particularly to these findings, but that is how the judge set it out. And I think the conclusion, my Lord, is that paragraph 5, isn't it? Which is that by January or February, he says, the information would have been entered on niche.
Mm.
And we say, actually, could have been done should have been done on the 21st of December.
Well, you've got a finding of fact, at least in relation to negligence, that if Sergeant Ellaby had done his job properly, it's likely that by January or February 2013, NP would have been entered in niche. And that's the high point of your case on causation and everything else. That doesn't assist us, does it, on Article 3? Or does that assist us on Article 3?
I accept your first proposition that it certainly helps us on causation. Do these findings of themselves assist on Article 3 up to a point? But there is more. And in ground 4, we set out the additional findings that we say the judge should have made.
Thank you.
And to remind myself what those were. But the first was that he should have sought advice as soon as he seized the laptop. He should have handed the investigation to a suitably trained officer who would have carried out a competent investigation. And the reason he retained the case and no investigatory steps were taken was his admitted desire to improve his own skill set, as he had yet to handle an images inquiry. And in order to retain the case, he evaded supervision and the appropriate procedures. And there is material which was before the judge that we say he should have taken into account. Bearing in mind, as I hope I'm right, Mr. Holroyde, in saying that no police officer gave evidence at trial. That was right. Yeah. So everything the judge found would have to be based on the papers. So maybe I ought to take your lordship to some of those documents. So, my lord, the supplementary bundle is probably the bundle your lordship should have to hand. And that bundle contains, and I'll just outline what it contains. D.S. Ellaby's interview in the disciplinary process, which formed part of his first interview with the Independent Police Complaints Commission, and in the second interview, which starts perhaps more revealingly at page 53 of that bundle, he was asked about matters. There are also interviews with his supervisors, to which I shall take.
Are you taking us to them?
I'm going to start with 53, if I may.
Thank you.
This is a record of the interview with Karen Cherry from the IPCC. And after introductions and so forth, questions began. Well, I may have taken to the wrong one. I'm so sorry. I think that was the prepared statement, and the actual interview is at 91.
91. Well, there is an interview at 53, but anyway, you want to go to 91.
Please.
Okay.
So he was asked whether he had done basic work, including, did you take any statements regarding seizing the laptop? No.
Where are we?
Sorry, 92, mid-page.
And that, I think we've got to add 2 for the electronic bundle.
Mm.
Ah, thank you, my lord. So he was asked about, did you take any statements regarding the seizing of the images that were downloaded on the laptop? No. Then he was then he was asked over the page, why was no one interviewed? And he was asked, well, you mean prior to seeing the results? Yes. Because my theories at the address were it was likely to be either blank, or an accidental virus, which was not something which featured as a consideration or a mitigating feature by the judge. Then on the
the blank is presumably RP, is it?
I presumed, Lord, yes. And then he was asked about why he hadn't issued a crime number on the face that a crime had been committed. And he accepted he should have done. Did you conduct any kind of formal risk assessment? He said, I'd never dealt with an images case before. This was really new to me and interesting, but also challenging. So
which page are we on?
96.
96 now, Lord.
With the electronic.
Thank you. Yep.
Then he said, I think the risk assessment is carried out by the high-tech crime unit. I suppose in answering your question, I provided information for the high-tech crime unit to form that risk assessment. We would comment, well, surely the most important thing is to find out who downloaded the images and work out whether that person has any access to children. And if we move to page 98, he's asked, can you explain to me why nothing's done? And he said, well, I don't claim to be very big with computers. I think the official advice is that you don't want to tamper with it because you may cause something else to happen.
Sorry, whereabouts? 98.
I've added 2 for the electronic bundle model. I'm sorry, shall I give both references?
Yep.
96,
So he makes your lordship's point, my Lord Holroyde, that yes, you have to be careful. He knew that much. Then he's asked at page 97 or 99 for the electronic. Is it the procedure that you don't question anyone in the house regarding those images until high-tech crime unit have confirmed that these are indecent? And of course, it was obvious to him that they were indecent. I think if my understanding of the procedure is that if you can definitely say that there's indecent images on a computer, then you can. You can take an early initial account from the people present about what they know about the handling of that laptop and the laptop history. I think if you suspect anyone to be a suspect. And so he had some idea of what to do, but just didn't do it. And then he was asked about the MP and what he understood about his use of the computer. It was put to him that he knew that MP was using it every day, and the answer was, I don't think every day, but he was one of the main users. And then he was asked, effectively, why didn't you ask him any further questions? And the answer was, I didn't suspect him. And I mean, when I looked at him, and he had a, you know, baby face, 16-year-old, coming across as really helpful. And that was something which was heavily criticised as being wholly, I think the words were inappropriate. I'll get the reference later, I'm sorry. And then page 101, paper 103 electronic, he's asked about supervision. Nobody actually seems to have come and spoken to you about the case, this is top of the page, and said, you know, Tom, what's happening with this? No. Where are we going with this? What lines of inquiry are we following? Where are we going next? That doesn't seem to have happened at all. No, I mean, by the time we get to August 2013, where I've been, where I write an update and I decide to close a niche, I haven't been spoken to by the line manager about it. You'll recall in the judgment that the judge made a finding that he had closed down the niche in August 2013. And it may be, as we'll come on to, that the reason he wasn't pestered by his boss was that he had closed the niche down. So it was dormant in my inbox, but for me looking at it, he says, at page 103, 105, 103 paper, 105 electronic, he's asked about, do you think, his answer to about crimed it, by which I mean, had he identified this as a crime on the system? And about closer scrutiny, because I wasn't sure if I was a virus. In hindsight, maybe I should have asked the question of the crime orders, but I didn't think I had a confirmed crime. But then he's asked, well, he then goes on to say, but I know that it's criminal to possess indecent images. Then at 104, 106, it may work, he's asked about middle of the page. It's put to him, it may well sit on the, it's easy for people to monitor what's going on. And I think the fact that you say that you know no one's actually sat down and spoken to you in quite a lengthy period of time, I think that's what you're saying, and he appears to agree, that monitoring process was absent. And he doesn't contradict that. And I think what we're saying is that it didn't happen. Yeah, it didn't happen. I mean, it doesn't stop the job from appearing on your list, but he wasn't being monitored. And over the page 105, 107, he talked about closing the niche down in August 2013. He's asked why he did that. And the answer is in the middle of the page. There's going to be this an inbuilt delay waiting for the high-tech crime unit, but they're going to come back to me and alert me with the results when they're ready. There's a cultural pressure to reduce the niche. After, you know, I've been there from January, I joined the shift in January, so we get to August 7 months later, and it's occurred to me that I don't need this task currently. I can close that and wait for the update from the high-tech crime unit. And then over the page at the top, I wanted an inbox that made my team look good, made me look good, and made my inspectors look good. then asked about why he hadn't registered or used whether he understood about the Police National Database. And the investigator said, well, that all came in because of SOAN. And the investigator makes the point about CRB checks.
But what are the particular features you want us to focus on?
Well, it's the lack of monitoring and the closing down of the system. So there's an element of system failure, we say there. It wasn't just Ellaby who manages to evade supervision.
Right.
Well, if I could take you to page 117, paper 119, electronic. This is a prepared statement that he gave to the index as a disciplinary panel. He gives his explanation at the bottom of the page as to why he took on the case. He says, as opposed to delegating, I saw this as a matter that I could assist with to relieve a degree of pressure on my team, as previously outlined. So we would say that's inconsistent with being plagued with other duties.
I'm very sorry, where are you?
At the bottom of the page of 117 paper 119 electronic.
I've got a paragraph that says the idea that an RSO.
Yeah.
Yes, that's right, my lord. And then in the middle of that, as opposed to delegating. Excuse me. Lord, at page 121, paper 123 electronic at the bottom. He says this, I returned the laptop for investigation for myself because I wanted to deal with it, and I had every intention of doing so. I thought it was interesting as an investigation per se, and knowing the waiting times for the HTCU to download the computer, I felt that I would be in a position to progress it when it was complete, as I did not think I was going anywhere. I could have handed it to another officer at Swindon at the time of my departure, but I recognised that dealing with an images case was a gap in my experience. There was going to be a delay waiting for the return of the laptop, which was not ideal. I felt it was something manageable, and then it could remain with me, and I could deal with it whenever the results came back. So the point we made there is that he was, that was the reason he did it, not because he was too busy. And that was a decision he made at the time of seizing the laptop. It's the combination of retaining for his own private purposes, if you like, not being busy, and evading supervision, which gives rise to the phrase lack of integrity in the disciplinary panel's finding. but although the disciplinary panel's finding related only to the second period, from the date of getting the computer back, in fact, more appropriately, it should have referred to the entire period. My Lord shakes his head. My Lord Stuart-Smith. You should go ahead, my Lord.
You shouldn't trust anything I do with my head.
Oh, sorry.
Right, where do we go next?
My Lord, the IPCC report, which is at page 141, paper 143, electronic, which deals with the investigation, of course, but at the end she lists Nick Elton's account, and I think I can just rely upon this, which is he was an inspector responsible for Salisbury, but his supervising, DS Ellaby's supervising officer for the period from 27th of January till 13th of June. And what he says is that he was not aware, DS Ellaby did not make, this paragraph 64, did not make D.I. Elton aware that he held any outstanding work from his previous role.
I'm very sorry, what page are you on?
I'm sorry, my Lord, it's 150
Okay.
or 152 electronic.
Yes. Paragraph.
Paragraph 64.
Thank you.
So this is our point that he evaded supervision. DS Ellaby did not make him aware that he had any previous problems. He had plenty of opportunity for telling him about the indecent images. And at 65, it was D.I. Elton's understanding that DS Ellaby had been advancing the due date of the indecent images investigation on the niche himself. And this resulted in the case not flagging up to him as an issue. He acknowledged that this was a flaw in the system. Officers should not be able to advance due dates linked to their own work. What he says was that had he been told that Ellaby still had responsibility for the indecent images investigation, he would have ensured it was returned to CID, as it was not the type of job that would be undertaken by uniformed staff. Ellaby was not a child abuse investigator, and the job did not relate to the Salisbury area. The next account is from D.I. Matthew Davey, who was the supervising officer since from 1st of July 14. And again, there was apparently a discussion with Ellaby about ongoing commitments. And Davey recalled Ellaby advising that he had an ongoing case, but not specified from his previous role in Salisbury, that would entail a court appearance, but nothing else was discussed. No further ongoing commitments were ever raised by Ellaby, and had he done so, Davey would have explored them and ensured that they did not conflict with his new role. So the idea that Ellaby, the primary excuse for Ellaby's failure to do anything was other duties, we say is not made out. He knew he was not trained for such a case. He was advancing dates on the system to disguise alerts. This is all flatly in contradiction of the NPIA guidance, which is in your Lordship's bundle. given the time pressures, I'm not going to take your lordships to it directly, but I think I can summarise the references that are relevant. So the extracts from this guidance start at page 190. I hope that's the electronic reference. Does that correspond to the front page of guidance on investigating child abuse?
190 in the...
Supplementary bundle that we've been looking at.
No.
192, I think.
192, thank you.
Yes. Thank you.
A lot of page 203 or 205, should I say, section offending by children. Sexual offending by children, even if relatively minor. And this is
Sorry, whereabouts are you?
1.4.19, my lord. And it's the final line there. Sexual offending by children, even if relatively minor, e.g. exposure may escalate to more serious sexual offending. And this should be referred to children's social care so that issues can be dealt with in an early stage.
Oh, sorry, I'm just not finding this. Can you give me a page, please?
It's 203 on mine, or 205 on yours, I think.
205, thank you. Oh, yes. Right, 1.4.
I think we've hopefully put a tram line there.
No,
No.
never mind.
So it's 1.4.9, offending by children.
It may escalate.
That's right.
I've highlighted the first paragraph for 1.4.19. Is that what you want us to look at?
The paragraph is the last 1, 2, 3, 4 of 1. It's the second paragraph, last lines of when children are reported to be abusing others, ... and the line starts, sexual offending by children.
Yeah.
Do you have that, my lord?
Yes, thank you.
Yeah. At 1.6, now the page is 206. Your bundle. The reference to child abuse investigation units, and it says at 1.6.1, final lines, the investigative role of the CAIU is important in such cases because its specialist investigators are in the best position to advise on and contribute to multi-agency working where there is a multi-agency dimension to the investigation. It is their specialist skills which will enable the safeguarding of the welfare of the child. This is the primary principle of any investigation and is described elsewhere. And we say, well, Ellaby was a million miles away from that.
But he wasn't investigating any child against a child at that stage.
Well,
subject to your argument that the treatment of the children depicted should have been investigated.
yes. Well, there is guidance on that relates specifically to indecent images. And perhaps I take the lordship to that. Lines of inquiry in cases involving child abuse images at page 217, my lord.
Thank you.
Or is this interviews?
No, my lord, it's 217 or possibly 215, I'm sorry. It starts 4.3.3, lines of inquiry.
Yeah.
And it sets out what may be thought to be fairly obvious points. paragraph 2, in addition to the intelligence relevant to the offence and the suspect, the package may contain a risk assessment. This can include an assessment of the suspect's likelihood of having committed or the individual's potential to commit a contact offence, e.g. direct abuse of a child. For example, would be someone who has regular unsupervised contact with a child. And we say, well, that just wasn't done because Ellaby was not aware that MP had any regular access to CJPJ, but he should have done if he had carried out a basic risk assessment. At the bottom of that page, my lord, in many cases the intelligence will provide reasonable grounds to justify the arrest of suspects for an identified offence. Although the full extent of their involvement in offences connected to indecent images of children may not be known at this stage, the opportunity to make an arrest should be taken where it is legally justifiable. So, my lord, we say that we don't say that he needs to be arrested on the 21st of December 12, but he should have at least been made, the phrase being a nominal, on initiative.
As should everybody else who was at the house.
That's the point.
No, my lord, I still stand by my conclusion that all he had to do was look at the files to establish that it was obviously he was the prime suspect. He would have spoken to him and he would have discovered, that was the judge's finding, that when he was spoken to, he would have told him everything.
I haven't understood the mechanism for all this. There's no arrest. Is this an interview under caution?
Well, let me go back and say, let's just take what the judge's findings were. And the judge has set out a mechanism. And I'm putting it more aggressively that it should be on the day of the 21st.
Understand.
It's a similar mechanism, just compressed.
Okay.
Detailed statement should be taken. I skipped that, but that's at 213.
Did you say 213?
I did, my lord, and I hope that's right. 215, I'm sorry.
But you're skipping it, so let's not take up time.
Okay, thanks.
Very well, my lord. It's there. My lord, it may be that I should move on to the law, which has been delaying us. I'm sorry for taking so long. Unless my learned leader wants me to point out anything else. So, my lord, may I deal with legal matters?
Please.
I think Mr. Warnock and I agree that there are 4 leading cases of primary consideration for your lordships, and that is X and Bulgaria, which my learned friend has cited in his skeleton argument.
Yep.
The 2 DSD cases, which we have referred to briefly, and a recent decision of the Court of Appeal in AB in Worcestershire, which is in the supplementary bundle. At number 36, AB in Worcestershire County Council, 2023. I'm sorry, we've got the Family Law Report 2023, 2 Family Law Reports at page 795, where the legal judgment was given by Lord Justice Lewis. So those are the 4 cases that probably need to take. May I start with X and Bulgaria, which is in the core bundle?
Or do you want to just tell us what you derive from those cases? Because time is moving inexorably on.
Yes, indeed, my lord. Yes. Well, we accept the way it has been set out by my learned friend in his skeleton argument, but there are missing parts of it which would help you, your lordships, come to some important conclusions. The first is that there is a repeated reference to the duty to protect the well-being of children. and that protection must be effective. And this is set out at paragraphs 176 and following
Of,
this case of Ex and Bulgaria, the Strasbourg case,
thank you.
2021. The case when the application number was 22457/16.
Right, okay, we can check that.
We accept, of course, that we must not impose an impossible or disproportionate burden on the authorities in relation to the Osmond duty. In terms of an investigation, it said that to establish the facts of the case and identify the appropriate punish those responsible cannot be considered to be limited solely to case of ill treatment by state agents. Any deficiency in the investigation which undermines its ability to establish the facts or identity of the persons responsible will risk falling foul of this standard. So it may be that these are not uncontroversial propositions.
No.
It is, however, constructive knowledge in the terms of the Osmond test. It is knew or ought to have known. And immediate risk is said to be present and continuing risk. And we derive that from Lord Justice Lewis in the AB and Worcestershire case at paragraph 60, and Lord Dyson at Master Rolls in Rathbone. My Lord, there is particular reference to the investigative duty in Ex and Bulgaria at 184. And the judges said they must always, that being the authorities, make a serious attempt to find out what happened and should not rely on hasty or ill-founded conclusions to close their investigation. And that's at paragraph 185.
Sorry, is that paragraph 184 of Ex and Bulgaria, did you say?
185, I said, I think it's the one following.
Okay, thank you.
(186) The obligation to conduct an effective investigation is an obligation, not a result of means. We've seen that. And at the end of 186, a failure to pursue an obvious line of inquiry can decisively undermine the investigation's ability to establish the circumstance of the case and the identity of those responsible. Paragraph 188, a requirement of promptness and reasonable expedition is also implicit in the obligation to carry out an investigation. And 190, nevertheless, the nature and degree of scrutiny which satisfy the minimum threshold of the investigation's effectiveness depend on the circumstances of the particular case. They must be assessed on the basis of all relevant facts and with regard to the practical realities of investigation work. So that suggests, perhaps, my Lord, the sliding scale that we refer to of Lord Justice Laws. I'll turn now to the DSD in the Supreme Court, if I may call it that. That's in the core authorities also. And DSD is at number 6. And your Lordships may recall that the leading judgment was given by Lord Kerr, and with one dissenter, although he agreed with the result, Lord Hughes. Indeed, I may begin with Lord Hughes on the question of threshold, which is at paragraph 128 of that case, and starting on my copy 257, possibly 259.
Yes, thank you.
And it begins the threshold of behaviour. And the concern he'd already expressed was that this was going to expand the obligations of the state too far. So he says this is more so when considering the range of behaviour which is treated as triggering the ancillary positive obligations under Article 3. Then he says it is also clear and routinely stated that what the minimum amounts to is relative and varies according to the circumstances of the case, such as the nature and context of the punishment, the manner and method of its execution, its duration, its physical and mental effects, and in some instances the sex, age and state of health of the victim. And he refers there to two corporal punishment cases, the second of which, A and United Kingdom, which is reported in 1999, 27 European authorities at page 611. That was a corporal punishment by a stepfather using a garden cane, which caused actual bodily harm on a 9-year-old child, and his defence of reasonable chastisement had succeeded in the criminal courts and held that this was an Article 3 matter. No doubt plain that in the case involving breach of the state's primary obligation not to inflict inhuman or degrading treatment, almost any physical injury perpetrated by a state official will cross the Article 3 threshold. When it comes to private citizens, the position he suggests is different. He says this: it is plain from the cases that the threshold is regarded as falling in English terms somewhere on the scale of actual bodily harm. To that must be added rape and child sexual abuse. Whether indecent assault passes the threshold remains unclear, but it is perhaps likely that it may, and we would say if it was indecent assault on a child, we would say that was more readily the case. So also one would think must be added false imprisonment, for example by relatives, violent disorder, most terrorist offences obviously, and many other crimes. It follows that the great majority of violent and sexual offences will trigger the ancillary positive obligation, and that potentially the investigation of all such offences might lead to an action under Section 6 of the Human Rights Act. So we could take a note of lament there, but that is what he says the position is.
Did anyone else associate themselves with these remarks?
Particularly on threshold, I would have to read the entire document carefully to
I think the answer is no,
Yes, I think that's probably right.
but if I'm wrong, could we be told?
Yes.
Thank you.
Well, so I rely upon that as an indication that the images of the children in the photographs would indeed amount to and pass the threshold for Article 3 harm, because the threshold is not so low, it's not so high, sorry.
Do we have a description of the photos somewhere?
Did your Lordship ask for a description of the photographs?
Yes, it is the one somewhere. I'm not asking you to tell us orally, but it is the one somewhere.
Yes, I did refer to it earlier, my Lord. I didn't read the words out because it's not very pleasant. But paragraph 10, I think it was.
Paragraph 10.
Paragraph 9, forgive me.
Okay, thank you.
Indeed, paragraph 8 and 9 give an indication of their nature of the judgment.
Yeah, thank you.
My lord, I'm parched. I was wondering if we might break now before.
Well, we can certainly break, but what is the timetable position, please?
I'll have to start
We haven't imposed time limits on people. With hindsight, I rather regret that. We've relied on you to divide the very considerable time allocated to this case appropriately. But I don't know what Mr. Warnock thinks his position is going to be this afternoon.
Well, I think probably about an hour.
Yeah.
My learned junior, Miss White, was going to address particularly the systems point, and insofar as it still pursued the operational duties point, I thought she'd been about 15 minutes. I have to say I had anticipated and I had thought we would be finished the claimant submissions by lunchtime.
Yes.
You may have
think we're all
noticed
assuming
passing notes which are getting alarmed.
Yes.
I have some good news for you.
Oh, good.
Which is that I am, in terms of the negligence argument, not covering control, not covering assumption of responsibility. I'm going to be taking you to Tyndall, making some submissions on making matters worse, touching on interference. I'll try to avoid fact, although I'll just sum up a few passages.
And how long's that?
And I would have hoped about...
We know. I think you can take it. We know Tyndall inside out now.
I'm
We're not going to finish this afternoon.
Or you could have an
How
article...
long you? Sorry, my lord is
I'm
should
sorry.
be asking the questions.
Sorry, forgive me, I'm
Well,
having...
I'm becoming increasingly pessimistic about finishing this within this afternoon. It's very disappointing. I think we'll rise, we'll discuss amongst ourselves how best to proceed. And we'll sit again at 2 o'clock, please.
All rise in favour.